get started. This is a hearing in the matter of docket number FIC 2013-775, a complaint by Isaac Avalucia, is that correct? Andy Tebow and the Torrington Register Citizen versus Donna Sherrero, Commissioner of the State of Connecticut Department of Emergency Services and Public Protection, Lieutenant Paul Vance, State of Connecticut Department of Emergency Services and Public Protection, and the State of Connecticut Department of Emergency Services and Public Protection. My name is Matthew Streeter. I am a commissioner and have been designated as the hearing officer in this matter. With me today is Attorney Paula Perlman, who is counsel to the commission and will be assisting me here today. Attorney Perlman can answer any procedural questions should you have any. I will note for the record that the time is 9:36 and today's date is July 30th, 2014. Our hearing is scheduled for an hour and a half. There is another hearing at 11, so we'll have to try and be timely so we can be out of here before they start. Will the parties identify themselves for the record, please?
Andy Tebow, registered citizen.
Okay.
Isaac Avalucia, registered citizen.
Good morning, Commissioner. Terrence O'Neill, Assistant Attorney General for the respondents.
Okay.
Morning, sir. Lieutenant J. Paul Vance of the Connecticut State Police.
I'm Attorney J. Don Francisco from the Legal Affairs Unit.
Okay. Based on what transpires here today, we will prepare a hearing officer's report, which will contain suggested findings of fact and conclusions of law. All parties will get copies of the reports in the mail, along with the date and time when the full commission will consider the report. The commission can adopt the report, reject it, modify it in any way, or reopen the hearing at the time of its deliberation. You'll be invited to speak to the commission on that day if you so choose. It is not required that you appear, but it is suggested, since, as I've said, the commission can change the report. If you decide to speak to the commission, you'll be limited to 10 minutes of legal argument per side, exclusive of questions of the commissioners. You could not present any new facts to the commission at that time. All facts need to get into the record today. We will follow the Uniform Administrative Procedure Act. The complainant will go first, present all relevant testimony subject to cross-examination and redirect if necessary. The complainant should present all relevant documents as well. Once the complainant is finished with their witnesses, it is the respondent's turn, who of course will follow the same procedure. Do you understand the procedure I have described?
Yes.
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 Yes, sir.
Yes.
Okay. Typically at this stage of the meeting, we can go off the record to enter any documents that we can mutually agree to, if anybody so chooses. If not, we can just move on with the hearing.
We have two exhibits.
Okay. Why don't we go off the record? Mr. Tebow? Mr.
Why don't you
Avalucia?
give me yours?
Okay, well, why don't you present it to the Assistant Attorney General?
I just have one copy.
What is it you're trying to?
The date's important.
Okay.
And the material in the article.
Mm-hmm.
Do you have copies for everyone?
Is it possible to make a copy quickly or not?
Or I can make copies afterwards. And if you
Okay,
have to
sorry
refer
we
to
didn't
it,
bring extra copies.
I'd suggest any exhibits that are marked, they can only have one copy.
So
They can get it online. It's
obviously, I have concerns about a newspaper article because of all the hearsay in there. I'm not clear of the purpose of the offer, so I'm going to object at this time,
Okay.
unless you want to have a conversation about the
No,
purpose.
no, they can bring it up at their part of the hearing and try to submit it at that point on the record.
I'm having a hard time hearing
Oh.
with your equipment going.
I would have to ask.
Okay.
Turn it off.
So if they object, you don't admit it automatically? If they object, you don't admit it till we talk about
That's
it later?
exactly, on the record. You can submit it. At that time, he can object, and I can ask you what its relevance is and make a decision, termination at that time, whether we can admit it into the record.
All right. I'll just state.
Well, we're off the record, so I mean, that's...
All right.
I mean, I'm happy to have a conversation in an effort to get to where they want to be with this, but obviously newspaper articles generally are not admissible as evidence.
This is FOI, it's not court.
No, I understand.
It's just normal and customary to have newspaper articles and an FOI hearing. It's rare that
Let's
there would
try
be
not
an
to
objection.
try this
All right.
hearing at this time.
Okay.
I just was baffled by where Terry was coming from.
Okay.
Currently, Attorney Perlman's going to check and see if we can get the amplification turned up for the audience. I'll try and speak louder. This room is tough to keep a even temperature.
You can confidently state the relevance.
Do you have any other exhibits?
Yes, we do.
Okay.
I didn't want to start pressing buttons.
Is there? Can you hear me now? Is it louder? Okay.
Thank you, Greg.
Okay. Do you have another document you'd like to
Yes.
submit?
Show it to these guys.
Yes, please.
Okay.
Commissioner, we're going to need a little foundation on this exhibit before we take
Okay.
a position on it. We're not sure where it came from.
Okay. We will not consider that at this time. We can put it on the record later. Do you have any other supporting documents, like responses from to your request, or we have the original? I think we have a copy of the original request.
Actually, I believe it's just a complaint.
Well, they
Oh,
can
just a
enter their
complaint.
response into the record if they want.
But you don't have your initial request, a copy of your initial request.
I have a copy of it. I thought the commission keeps a copy of that, and that would be part of the record.
We don't have.
I don't see a copy.
It's right here. Mine has writing all over it.
Oh, no, not the complaint. The
The response.
actual request that you made to the agency.
Oh,
Is that it?
that's from you?
Yes, that's right.
That's what I have as your first one. Do you want to make a copy of that and use that? That's my copy.
Oh, whatever you think.
Unless if you want to submit the documents, so we can have something for the
I'm happy
record.
to. I wasn't expecting to, so I only have one copy of this one. But we can make copies at any time.
And do you have any copies of your responses to the
Oh, I have-
complainants?
Never mind. I have an extra copy,
Oh.
so I can just.
We'll still need to make a copy.
Is that okay?
Do you-
Thanks for your courtesy there.
Of course.
So this
And
is
do you have
the-
any? And you have no objection to the?
No objection.
Okay.
And
So
then.
I'll mark it as respondents one, since
Okay.
you're submitting it.
Do you have any other documents? They seem to have no other documents.
We just have those two that we,
Those two and, okay. And do you
and
have
the one that you
objections?
submitted as a courtesy for us.
And this is a response? to
This is the
request?
acknowledgement
Oh,
letter.
acknowledgement.
I don't know that there's a dispute about the response. I think my understanding is that this is a promptness issue,
Correct.
right? So you received the records. Your problem is that you feel you should have gotten them sooner, right? That's what we're hearing.
Correct.
Yeah, so I don't think
Yes,
there's a dispute
that's
about the
correct.
adequacy of the response.
Okay, I'm taking this from the point that I'm starting with a clean slate.
I'm
that-
sorry, I'm just trying to.
I understand what you're
I'm trying to
saying.
get you in for your 11 o'clock hearings.
I understand.
This is the,
I don't have a problem with what he said
That is-
at this time.
Respondents.
That may change.
Okay, do you want, we would just make copies afterwards, or do you want to do that now? Unless, we can do it afterwards, I think. All right, so why don't we go back on the record then?
no additional,
Nothing additional this time.
Okay, while we're off the record, we did, the complainants and the respondents mutually agreed to 2 exhibits. Attorney Perlman, if you can read those into the record.
The exhibits that have been stipulated to have been marked as Respondents Exhibit 1, November 23rd, 2013, email request from Mr. Avlucia to Paul Vance, and Respondents Exhibit 2, it's a November 25th, 2013 letter from the Department of Emergency Services and Public Protection to Mr. Avlucia. Are these records that the parties have stipulated to?
Yes.
Yes.
Okay. At this time, I will swear in the witnesses. Anybody that's going to be a witness today, if they could please stand and take the oath.
I didn't plan on it, but maybe I'll do it anyways, just in case.
Okay, do you solemnly and sincerely affirm that and declare that the evidence you shall give in the case now in question shall be the truth, the whole truth, and nothing but the truth, but upon the pains and penalty of perjury?
Yes, sir, I do.
I do.
Okay. For the record that Mr. Tebow took the oath, Mr. Avlucia took the oath, Lieutenant Vance took the oath, and the attorney. Can you spell your last name for me?
Sure. Don Francisco, D-O-N, capital F, R-A-N-C-I-S-C-O.
Attorney Don Francisco took the oath. Did I miss anybody? Did anybody?
Just a mechanical point. I will have a question or two for Attorney O'Neill, but unlike other lawyers, I don't think I need to put him under oath because I trust his word. Can I ask you a couple questions later?
Depends on the questions.
Yeah.
You have my, you have my word. I will testify truthfully.
Yeah.
Okay, at this point, we will now let the complainant begin their case.
Are we going to put those records in, those exhibits?
Okay, if you want to
Start with
this
that?
time. Sure.
Want to do yours?
This is a December 29th report from the Republican.
Yes, once again, give it to, yes.
Speak up. Speak louder.
And what is this the article?
It is an article about the wife in question, the sergeant's wife, and it's materially important because it produces parts of a report that was not produced to the registered citizen when we asked for it.
And you had objected to this?
Yeah, I would object on a number of grounds. And first of all, the article includes multiple layers of hearsay. And I don't know, it's not clear, and I'm not trying to be hyper-technical here, but it's not clear to me whether the plaintiffs, the complainants, are offering this for its truth or if they're offering it to show that something happened on a certain date, depending on, but certainly there are multiple layers of hearsay. Second, I would respectfully submit that with respect to the report itself, the report that's the issue of the complaint, the Connecticut Supreme Court has decided that the report is properly withheld by law enforcement.
You can't go retroactive.
Until the conclusion of the criminal charges. That was the Department of Emergency Services and Public Protection's position for years and has been litigated for years before this commission and now the Connecticut Supreme Court. So to the extent that there is still a claim in this case that the report should have been produced prior to the conclusion of those criminal charges, I would submit that as a matter of law that issue has been decided and is not properly before the commission at this time.
I'd like to respond to that. May I respond?
Yes.
Thank you. So I think the objections by the respondent are lame, pro forma, and disingenuous. The real reason they don't want it in is because it shows they gave preferential treatment to another party that had requested the documents. We're not offering it for the truth of anything except to show that the state police gave these documents or records to another entity after we filed our FOI complaint. And it's normal and customary for the commission to accept such documents. So they're objections without any merit whatsoever.
I appreciate Mr. T. For years, I've appreciated Mr. Tebow's passion, and so please note a continuing objection to the occasions where his passion becomes name-calling of me or others. I won't respond to that. I don't think I need to. Having said that, if the purpose of the offer of this article is to show that somehow the state police or some agent of the state police gave a report to one newspaper but not another, the article doesn't say that. So it's not probative of that fact. I would submit that that's not relevant. It's not properly before the commission because of the argument that I made regarding the recent Supreme Court decision. But even if you were inclined to consider a commissioner, the article doesn't say that. So
Okay.
It's not probative of that fact.
Okay, I'm going to uphold the objection. I'm not going to allow this exhibit, but you may ask questions.
We'll refer to it in testimony, and we'll show why it's important and why they didn't want it in the record.
Okay.
I didn't call you any names, I just characterized your objection.
Is there another document you'd like to
Yes, there is.
show it to Attorney O'Neill?
Commissioner, when we had our off-the-record discussion, I indicated that I was objecting to this second proffered exhibit because I didn't understand, it lacked a foundation. I don't understand who created it, where it came from, and so without waiving any other objections, right now my objection is it doesn't seem to be an authentic document, so I question its authenticity, and I object as to its lack of foundation.
I'll swear under oath it's absolutely authentic. It's a copy of a state police document we obtained that gives all the information. It demonstrates that all the information we asked for on November 22nd, 2013 was immediately available on November 16th, 2013.
What document is it part of?
It's a state police document. It's a report of the incident filed by Trooper Lance Carlson the night of the incident.
Perhaps if I could put some structure, I know we're not subject to the formal rules of evidence, but if perhaps I could voir dire, that is, ask some questions of Mr. Tebow about its creation, maybe that would help create a record with your permission.
Okay, we'll allow it.
Mr. Tebow, who typed this document?
I believe that Trooper Lance Carlson typed it. I just copied it.
So there's you have a copy of the document in front of you, correct?
I have, yeah.
And on the top it says there's some color coding on here.
That's all my stuff.
All right, so you color coded this.
I'm sorry. I color coded up until the red part. The red part all the way down is from Trooper Lance Carlson, created the night of the incident in question.
All right, so when I asked you who typed this document, did you type verbatim certain words that you found in a report?
No, I copied an original.
So if you can indicate for Commissioner Streeter, what portion of this document was copied by you, and what portion of it, if any, was typed by you?
Okay. The part that I typed was document available the night of the incident, November 16, 2013, requested the following week on November 22, 2013, not produced until after April 10, 2014, and then below that beginning FS 13-007-16978, domestic arrest / discharge of a firearm, Salisbury, 11/16/2013, 22:29 hours. From there to the bottom is all the trooper's work.
It's the trooper's work that you copied verbatim by typing it onto a document, correct?
I did not copy it by typing, but I made a copy of it. I block saved it.
Okay, so you had an electronic version of the report that
Yeah, I
you
did.
blocked, cut, and pasted.
That's correct.
Okay, so above the red in the middle of the page, everything above that is something that you typed, for example?
That's correct.
So the top part, exhibit to be entered, et cetera?
Yes.
Okay, obviously I object to the document. It lacks a foundation. If the purpose of the offer of the document is that there was information contained in a police report that police report was written at or near the time of the arrest that's the subject of this request, I'll stipulate to that. I'll stipulate that there was a police report. That's I don't think anything that's in dispute. The question here is whether the respondent had an obligation to produce that police report at some time prior to the date that it chose to do so.
Okay, I'm gonna affirm the objection and not accept this document. It's a document that was cut and pasted together.
Well,
Whether the authenticity, you may have cut and copied other things. It's just something I'm not going to be able to look at. If you have a copy of the actual police report without any edits to it, then that might be something that you could proffer forward.
I'll just briefly state my objection to what I surmise is your ruling. This is the smoking...
You're objecting to my objection.
All right. However you want to put it. This is the smoking gun that shows that we could have gotten this public record we sought. A third grader could have clicked on it and sent it to us. Instead, we had to wait for 4 months. So that's why they don't want it in the record.
You can,
Go ahead.
You can always ask questions when you have an opportunity to cross-examine the witness.
Okay, thanks.
Okay, so if you want to continue with the case.
Yeah, okay. The case. I just need a drink of water. Thank you very much. I'll just say at the outset that known Assistant Attorney General O'Neill and Lieutenant Vance for many years, and on many or most or a lot of occasions, they both acted professionally and with integrity, but not, I'll say in this case, Lieutenant Vance, not always. And I have a very short statement, and then I'll call my first witness. This is a very simple case. It is reprehensible, outrageous, obscene that the Connecticut Attorney General, apparently on automatic pilot, without any proper diligence or consideration, elected to waste the hard-earned money of Connecticut taxpayers by representing Lieutenant Paul Vance and the Connecticut State Police in this heinous effort to justify the hiding of public records. Consider this. After a number of verbal and written requests for public records were made in this matter, Lieutenant Vance stated it was up to the state police to interpret the FOI law demanding prompt production of the people's property. Let's pause and absorb that. Vance, in effect, stated, "I'm the decider." For this alone, Vance should be fined $1,000, strung up in the public square, just like in the old days, in the public stocks, for the shame and dishonor he has cast on the CSP and the citizens of Connecticut.
Commissioner, I'm going to interrupt at this point. This invective is completely inappropriate. Not only is it inappropriate, the Connecticut Supreme Court has said that the conduct that was engaged in here by my client agency is a perfectly appropriate interpretation of the Freedom of Information Act. This is outrageous. The argument is about to be made one step further that we shouldn't even proceed any further.
I'd like to finish. He got to finish his.
Okay. If you could, just focus yourself to the facts of the case. When basically when you made the request, what you got, when you got it. Let's try and keep this, civil. I know you've used a lot of words: reprehensible, heinous, shameful, strung up in the public square. I think if you can try and cut through some of that. And let's.
Why didn't even get to Orwellian?
The objection was that let's try and get this. This focus.
The bottom line is that the state police cannot be a law unto themselves. They don't define promptly, and I'm skipping over a lot of stuff.
I would respectfully submit we should skip over all argument. If there is any argument, that can be made in a post-hearing brief. It can be made before the full commission. This is a fact finding. I would respectfully submit that we should spend the rest of our time here discussing the facts.
Okay, so you can try and stick to the facts here. So
Well,
proceed.
Before I do that,
Now let's try and get to the.
well, I just want to state my objection to your ruling. I can do that, can I?
Go ahead.
All right. It's normal and customary for a complainant to have a layperson's latitude to make a statement.
And we're giving you that.
Why, I only got through 1/3 of it, and I could have been finished by now. So I think this is wrong of the commission.
No, just try and keep things civil, please.
Civil?
Yes, sir.
I didn't call, no,
You didn't call what?
never mind.
You're gonna
All right, I'll call my first witness. Isaac Avalucia, reporter. Why did you go to the Canaan Barracks on November 22, 2013?
I went to obtain a report based off this domestic dispute between Sergeant Cole and his wife that took place at the Interlaken Inn on November 16th.
And what happened when you went to the Canaan Barracks?
I was referred back to State Police Headquarters, referred back to Lieutenant Vance, and was told that I had to make an official inquiry to obtain a police report of the incident.
And did you ask for the report to be provided to you promptly?
Immediately.
Yeah. Okay. Then what happened?
Like I said, I was not provided the report at the barracks, so I followed up with a verbal and formal request to Lieutenant Vance over the phone, and then again in writing on November 23rd.
Okay. And what did Lieutenant Vance tell you when you wanted the report?
He said that I had to submit a formal request and then it had to be processed, and that his agency was the decider of what constituted prompt.
He said the agency was the decider of
He
what?
said he was the decider, quote unquote, of what was prompt.
Oh, okay. And did you have any further discussion with him regarding that point?
Yes, we had some discussion.
How did that go?
Well, it didn't lead to anywhere because I didn't get my documents produced until 4 months later.
Okay. Are you familiar with a story that ran in the Waterbury Republican American on, what's the date here?
December 29th.
And that was approximately...
That was approximately 17 days after we submitted our official complaint with the commission, citing non-compliance with the prompt part of the state's law. That was approximately 37 days after an initial request of the documentation of the actual police report.
And did you notice anything in this story that ultimately came out in the police report?
It was a outright. I was pretty upset with it, as a matter of fact, because you know,
we don't care about your feelings, but
our competitors
what you see in
our competitors were provided a copy of this report that had all the relevant details that were
I'll object
available
at that point.
on
I'm
November
sorry,
16th.
sir. I'll object and move to strike. There's no foundation as to how the Waterbury Republican obtained a copy of the report.
Okay.
let me ask another question related to that.
May I just have a ruling on my objection first?
Objection or...
Well, I
Sustained.
can
Sustained,
sit
sorry.
here
Let
and
me
say
ask
that
you
it
another
wasn't in the
question.
case file. So where did it come from? It wasn't in the case file at court.
He made his ruling. We'll go around it. So you're batting 1,000. Are you familiar with a report written by Trooper Lance Carlson the night of the incident?
Yes.
And did you see any of that reflected in the Waterbury Republican story?
Yes.
What'd you think about that?
Objection, speculation.
Sustained.
I didn't ask him how he felt. Okay. So again, you're familiar with the report written the night of the incident by Trooper Lance Carlson.
Yes.
And how does that differ in any substantive way with the documents provided 4 months later by the state police?
Little, if at all.
I'll leave it at that. You're a witness.
Mr. Avalucia, I'm Terry O'Neill. We just met today for the first time. You and I don't believe, have ever spoken before. Is that right?
We've spoken over the phone.
Oh,
briefly.
when we talked about
Correct.
scheduling this, that's right. I apologize. You are a reporter for the Torrington Register-Citizen, correct?
Yes.
And you are the complainant in this case, right?
Correct.
And if I understand your complaint correctly, you have now received a copy of the report that you were looking for back in November, correct?
At least 4 months after that.
Okay. So your complaint today is focused on whether or not you received that report promptly, right?
It is focused on the inadequate compliance with the law.
Okay. Can you answer my question? We're going to have legal argument at some point, but you would agree with me that as of today, your complaint is focused on whether or not you received the report promptly.
I did not receive the report promptly.
Okay, so your complaint today is
Correct.
that you didn't, all right, and that is all that your complaint is about today?
No,
Promptly.
that's a stipulation of the law, and I would contend that our complaint was not produced adequately, and it was not produced properly, and I would contend that it was an inadequate production of the document of when we asked for it.
Okay, so when you say that the report was produced inadequately, you mean that it should have been produced to you before April of this year?
It should have been produced promptly.
Okay.
As in, I contend that it should have been produced immediately, given the fact that it was available November 16th on the date of the incident.
Look, all I'm trying to do is get an answer to my question. So is this a true statement or a false statement? True or false? You contend in this case that you should have had the report produced to you before April of this year. True. I have no further questions.
Okay. Any redirect of your witness?
No, but Isaac has some questions for Lieutenant Vance, and then I'll have some.
Okay. And you're concluding your...
I'm all done with him.
Okay. You have no other witnesses to call?
No?
Okay. Let the respondents go.
Sure. We'll call Lieutenant Vance. Lieutenant, you're employed by the Department of Emergency Services and Public Protection, correct?
That's correct, sir.
I understand you recently celebrated an anniversary.
Yes, sir, I did.
So how long have you been with DESP?
40 years, sir.
Congratulations.
Thank you, sir.
And your current assignment with the agency is what?
I'm the spokesman for the department, public information officer for the department.
How long have you held that position?
Approximately 14 years.
And can you just tell us generally what your duties are in that assignment?
My duties are to make every effort to make available press releases and press information on accidents, incidents that occur throughout the entire state of Connecticut.
Is it your duty or assignment to represent the agency in complying with Freedom of Information Act requests?
It's my responsibility to submit and provide releases, but as far as freedom of information, that is another portion of the agency that handles that responsibility.
What portion of the agency is that?
Legal Affairs Department, sir.
And what is your understanding of why within your agency Freedom of Information Act requests are handled by the Legal Affairs Unit?
To ensure that we're in compliance with the law, to ensure that any adjustments or redactions that need to take place are handled by the Legal Affairs staff.
Within your department's report requirements, your troopers, when they make arrests, for example, they're required to write reports, correct?
That's correct, sir. Yes, sir.
And as part of that report drafting process, are troopers also required to write press releases?
Yes, sir, they are.
And so is it fair to say that within your writing and reporting requirements, press releases that are generated as part of arrests, for example, are released to the public, the media, through your office?
Many of them are, and they're also, press releases are available at the location where the arrest is made at the troops throughout the state.
Okay. Whereas the disclosure of police reports, incident reports, and the remainder of the documents, the release of those materials is handled by another unit in your agency?
That's correct, sir.
Not by you?
We do not handle reports at all, sir.
Do you have a recollection of having some communications with Mr. Avalucia regarding an incident that occurred at the Interlochen Inn back in November 2013?
Yes, sir, I do.
Do you recall when you had your first contact or communication with him?
The exact dates I can't, sir, but it was after the arrest of the accused in that case had taken place.
Do you remember the date that arrest occurred?
Yes, sir, I have it in the press release. It was November 16, 2013.
And do you have an indication of when the press release related to that arrest was completed by the arresting trooper?
Yes, sir. The press release was authored on 11/17 at 1:50 a.m.
Now, 11/16, do you recall what day of the week that was?
I believe that was a Saturday, sir.
And the trooper completed the press release early in the early morning hours of Sunday?
Yes, sir. That's correct.
And at the time that press release was completed, was it available to the public or anybody else?
It would have been available soon thereafter once it was signed off, if you will, or approved by the duty supervisor.
Do you have any indication or recollection of when the press release was completed?
It would have been available the next day. I don't have the exact time, sir.
The next day, meaning November 17th?
Yes, sir. That Sunday morning.
Do you recall, do you have the respondent's exhibits, Commissioner? Yes. Do you recall at some point in time receiving an email from Mr. Avalucia? We've marked it as respondent's exhibit.
Yes, sir. I received that on November 23rd, which is a Saturday at 4:45 in the afternoon. And when I say I received it, that came to my inbox, my email inbox.
Do you recall, well, withdrawn. Right above the text of the email from Mr. Avalucia is a to and from portion of an email that indicates you sent a copy of this to somebody in your agency.
That's correct, sir. Yes, sir, I did.
Who did you send it to?
I sent that to my secretary.
That's, and why did you send it to her?
Kathleen Beck is my secretary, and she is responsible to make a copy for our files to indicate that we received it, and we transmit it immediately to Legal Affairs to ensure that it's properly put into place as an FOI request.
Did you have, withdrawn, what, if anything else, did you do with this Freedom of Information request?
I would have taken a hard copy to the Legal Affairs Department to place it into a formal application for Freedom of Information.
After delivering the Freedom of Information request from Mr. Avalucia to your Legal Affairs unit, did you have any more involvement or with the processing of that request?
No, sir. Once a FOI request is submitted, I no longer have anything to do with the FOI request. That's strictly and solely in the hands of Legal Affairs. So
showing you Respondent's Exhibit 2, that is a letter from the Legal Affairs Unit to Mr. Avalucia acknowledging his request on November 25th, 2013.
Yes, sir.
In the normal course of business in your agency, you would not have had any involvement in the drafting of that letter?
None whatsoever, sir.
Would you have even had received as for your own files a copy of that?
No, sir, not at all.
So between, withdrawn, around the time that you received this email, this electronic communication from Mr. Avalucia, do you recall having a conversation with him?
Yes, sir, I did.
Do you recall if it was before or after the email?
Specifically, I don't recall, but I believe it may have been after, sir.
What do you recall of that conversation?
I recall the reporter calling, requesting additional information about the investigation, reports, tapes. There was a list of things that were discussed, which the reporter had requested that I provide for him.
And do you recall what, if anything, you said to him in response?
Yeah, I certainly do, sir. First of all, I do not provide reports. That is not my responsibility. Seasoned reporters know that we have a Reports and Records Bureau that manages that and takes care of the providing of reports as requested. I described the FOI process and the fact that once an FOI has been submitted, that I'm out of it. I'm done. I no longer can help or participate at all. It's in the hands of Legal Affairs. And I provided that information to him. At no time did I ever say that I was a decider of what goes out, when it goes out, how it goes out, or what time it goes out. That is not my responsibility.
Lieutenant, do you recall having any discussions with anybody in your Legal Affairs Unit about how to handle this or whether it should be?
I did have conversations when I received the copy of the complaint with Legal Affairs, yes.
And after the delivery, the initial delivery of the complaint, did you have any further communications even with the Legal Affairs Unit?
We have, in preparation for today, we did discuss.
Other than preparation for the hearing?
No, sir, I don't recall.
The doesn't appear to be an issue at this time. The parties agree that the report was eventually given to Mr. Avalucia sometime in April of 2014. Were you involved at all in the process of delivering that report?
Not at all, sir.
Who was?
That would have been legal affairs, sir.
During the time that this freedom of information issue was going on, of course, you were aware that there were pending criminal charges against an individual who was arrested as part of this incident, correct?
Yes, sir, I was.
Do you have any knowledge as to when those if at all, those criminal charges were disposed of?
Recently, sir, within the last, I'll say, few weeks, 2 or 3 weeks, very recently that was disposed of, sir.
Okay. So the reports in this case were disclosed to Mr. Avalucia before the termination of all the criminal proceedings?
Yes, sir.
May I just have one moment?
Sure.
I have no further questions. Thank you.
Okay. Have any questions of the witness?
Start
Yes.
with Isaac.
Good morning, Lieutenant Vance.
Good morning.
This case is about promptness. You sat there and informed Counselor O'Neill that you at no time said that you were the decider of prompt. Are you saying I'm a liar?
I would never call anybody a liar, sir.
So who's lying, you or me?
Sorry, I tell the truth.
I'll object. That's
Yeah.
argumentative and confrontation.
I'll ask him if he denies saying.
Do you deny saying that?
I deny saying that, sir. Yes, sir, I do.
It was produced as part of my report. It was factually in my report that you were on record saying that you and your department were the determiners of what is prompt.
Is there a question there?
Did you object to that at any time?
Do you object to that?
Did you object to that at any time?
You disagree that you ever said that statement or ever said anything close to resembling that statement?
I'll object to the form of that question.
Excuse me, Mr. Avalucia, you said to your report. What report are you referring to?
I had a report in the Registered Citizen within a few days after.
So an article that you
an
read.
article in
Thank you.
Registered Citizen. Did you ever object to the article as it was printed? Did you ever phone me and indicate to me that you never said those things?
Which article are you talking about, sir?
I'm talking about.
Object. This is argumentative. It's irrelevant.
You're referring to an article that you wrote?
An article that I wrote in the Register that appeared in the Registered Citizen.
Okay, we don't have a copy of that for here. But I'm going to sustain the objection. I don't know the relevance of these questions. You're supposed to be, at this point, asking questions and not referring to something.
We'll just have a few more questions from Isaac. Lieutenant Vance is on the record denying that he said he was the decider of promptness. And
Yeah, and it was asked and answered. I don't know
Yeah,
how many
okay.
more ways you're going to...
all right.
I'd like
Do you have
ask
anything
this,
else?
Lieutenant Vance, if one of your underlings, you pressed one of your underlings, you asked him to print off and supply a report to you, and he produced that report 4 months later, would you say that that is prompt?
I'll object. Yeah, it lacks a foundation. We don't even have a testimony that Lieutenant Vance has underlings. I don't know what's meant.
It's just... Well, go ahead.
If you want to just rephrase the question. Neil, I believe I understand where you're going. I just wanted to know if a response that took 4 months, whether or not Lieutenant Vance thinks that 4 months to give a report is prompt. And I believe that is what you...
I'm a lay person. I don't have
I
a
believe
law
that's what
degree.
it is.
That is the foundation of my question. I'm asking you, Lieutenant Vance, if if you pressed one of your troopers to produce a report to you, if he produced that report 4 months after you commanded it, would you think that's prompt?
I would have to look at the circumstances of what that trooper was producing for me, first of all. Second of all, I do not have the responsibility to obtain reports from troopers, so I would never give that order.
Well, I'm speaking generally. I'm asking you if you task one of your troopers with something that didn't require a lot of thought or process, and he completed the task 4 months later and informed you that he was the decider of prompt, Would that offend your sensibilities?
I'd have to consider all the facts and circumstances in order to answer
And
that
what would
question.
those
I'm sorry.
facts and circumstances be?
The type of case, the amount of work that was involved, the list of going on and on, interviewing of witnesses, gathering of evidence, laboratory analysis, whatever might be involved. It might take 4 months to finish a case or to do the information or provide the information to me.
What is your understanding of this case? Would you define this case involving Sergeant Cole's wife, Ellen, as a complex investigation?
Objection, irrelevant. The Connecticut Supreme Court has indicated that General Statutes 1-215 governs the production of police reports while charges are pending. The record is indisputed here that during the entire time that we're talking about, charges are pending against this individual. The release of reports is entirely within the discretion of the law enforcement agency, balancing all kinds of factors, including the fact that the person charged with that crime was innocent at the time.
It's relevant.
I'm going to
because it goes to
sustain.
the
I'm going to
totality.
sustain because I'd like you to keep the questions to what's germane to the FOI, not the actual what's going on inside that case is not relevant to the jurisdiction we're here. It has to
I
do-
would argue that it is relevant because this is not a complex investigation, is what I'm trying to establish. And this report was as easy as pushing a button.
The determination of what happened in that case is not the issue here. It's dealing with the problem.
What's at issue is Lieutenant Vance's definition of prompt. And he said that it depended on the totality of the circumstances.
And I agree with you on that. But you're asking now about something internal of the case regarding the charges that were going.
Ask him what the burdens were to produce a crime.
I'm going to Attorney Perlman. Okay. Well, if you want to explain that.
Mr. Evolucci, is your basic question, I think, right, why did it take so long? Is that where you're...
I want to know if Mr. Vance believes that the investigation involving Ellen Cole was complex. Was it multi-tentacled? Would it have to occurred over 6 weeks? Is it as complex as a murder investigation? Is my general question.
Should I ask the question? Okay, I'm just going to ask the question to
Maybe we just
him.
have-
Okay, sure, of course. Okay. So we don't need to know the complexity. Do you have an answer to why you think that it took several months for the record?
So I think the answer to that question is that I don't produce reports. Reports are produced once an FOI request has been submitted by Legal Affairs. And I don't know what their process, I don't want to know what their process is. They have enough on their plate. But I am not at liberty ever to produce a report for any reason for anyone.
Okay, thank you.
Yes, sir.
Will you have a witness to testify as to why it was 4 months later? I know that you have another witness. And
I have a representative from Legal Affairs here who can describe the timeline. The individual attorney who was working on this file and produced the report is no longer with the agency. He's working for the city of Hartford.
So, Mr. Evolucci,
But I would submit it's irrelevant because, for the reasons that I was stating.
I still think that you'd have an opportunity to ask the second witness to get an answer to your question.
Okay, well, I'd like to know if Lieutenant Vance is aware of 43 complaints against state police citing non-compliance with the FOI part of the law, and the vast majority of those citing prompt production as the reason for the complaints. Are you aware of that?
No, sir, I am not. I have nothing to do with FOI complaints.
So why do they call you the public information officer for state police if you have no public information?
My assignment, sir, is public information, media relations, and my responsibility is to divulge press releases to the press all across the state on a daily basis, not reports.
To your knowledge, has state police or yourself ever been fined by the FOI commission for non-compliance?
I have never been fined by the FOI Commission, sir, and I have no knowledge of whether the State Police Department ever has, sir.
If the FOI Commission had fined you in the past, would it be safe to say that you would be more intention to comply with state law if they had fined you in the past?
Objection.
Sustained.
How often does state police work with Newtown police on a professional level?
Objection. It's irrelevant.
What's the relevance of the case now in question?
I contend that the reason that this document wasn't produced promptly because on some level state police were involved in a culture of blue code and were covering for Newtown police.
I'm going to sustain the objection. Continue.
I have no further questions.
I have some questions.
You have a question too?
I have a number of questions.
I'm sorry, I didn't understand that the proceeding would allow for dual questioning of witnesses. We have,
Well,
They're both
named
listed as
complainants.
complainants. If you can move this along, otherwise you're not going to get to the other witness. We're going to be up against the 11 o'clock. So if you can, do your questions quickly, unless you're going to, because if you.
I have questions prepared, and I'll get through them as expeditiously as possible. I will note for the record that every ruling, without exception, whether it's documents or testimony, has gone in favor of the respondent. And I'd ask the commission to take note of its duty to the people to provide public information. I have a three-part, well, Lieutenant Vance, you stated you make every effort to provide public information. And is that because you feel it's important that the public believes the state police has credibility, so it'll help you and trust you? Is that why it's important?
No, sir. It's my responsibility when troopers conduct accident or criminal investigations to ensure that all members of the media, whether it be electronic or print media, are provided with whatever documents relative to press releases that they request to explain that incident, sir.
And if I understand your testimony correctly, you're saying that's without regard to the public trust.
I don't understand your question, sir. I'm sorry.
Do you factor in the public trust when you engage in public information or public relations or whatever it is that you're saying that you're doing?
objection.
Yeah, I'm not understanding what you're getting at with public trust. I mean, what's the relevance to this case?
Well, if people don't trust the police
Yeah,
or
but that's
believe
not the
them, they
issue
won't
here.
help them.
Please continue.
Well, it's a core issue. Now, your legal affairs department handled the report submitted by Trooper Lance Carlson, correct?
Yes, sir, that's correct.
And besides deleting 2 dates of birth, what did the legal department and all its expertise do to that report before you gave it to us?
Again, as I stated, I have nothing to do with FOI, sir. I have nothing
Right.
to do with the response to an FOI.
Okay. I have a 3-part question, and then I think I'll be done. Lieutenant Vance, how long does it take you to edit and forward a readily available half-page document?
Objection. This has been repeatedly asked and answered. Lieutenant Vance had nothing to do with the handling or the processing or the releasing of this report.
I object to his objection.
Yeah, I'm going to sustain that.
They could say the cow jumped over the moon and you'd just sustain their objection. The core issue is they had a report readily available on November 16th. They denied it on November 22nd, and we didn't get it till
I
April.
sustained it because the question was of Vance, and Lieutenant Vance has answered a number of times. He does not have any, nothing to do with the FOI question.
So if you want
You're asking
public
the same
information,
question.
you're supposed to go to a lawyer to get it for the state police? Why didn't you give Isaac the documents you requested in a timely manner?
I understand that he was provided with the press release, which is my responsibility. Anything over and above that, sir, is not my responsibility.
I'm done.
You had no cross.
I have no reason.
Okay. You have another witness you'd like to call?
I really don't. I'm happy to rest on this record.
Well, the commission could ask the state police lawyer to testify as to the reason for the delay.
Okay, well, I may have a question for the Legal Affairs Department, if I may.
I asked that he be sworn in under oath as all other witnesses
He
are.
was sworn in.
Okay.
I assume that the testimony will be come from.
Yeah, for the record, Attorney Don Francisco took the oath. He's a member of the Bar of the State of Connecticut and an officer of the court. And while I don't think an oath is necessary, his representations are certainly true.
Okay. Attorney, it has been, we've had testimony that it is the Legal Affairs Department that handles FOI requests. Is that true?
That's correct.
Okay. And are you familiar with the case before us today regarding Mr. Avalucia, Mr. T-Ball, and the Torrington registered citizen?
I'm minimally familiar with it. I did not work on it.
Okay. And I think we had some conversation from the attorney that the attorney that was handling this is no longer with the department, and that's
correct.
Your understanding as well?
Yes.
Do you have an idea why this was a 4-month process for the FOI request to be moved forward to this?
Without speculating, no, I don't.
Okay.
I can say in general that the department is very, very busy with FOI requests. In 2013, we received over 1,000 FOI requests, and we have a limited staff, and we try to get everything as expeditiously as possible. We also rely on various other agencies within the department to provide information to us that is the subject of these requests. So a lot of times we are relying on other people in part to fulfill the requests, and to that extent some parts of requests are out of our hands till we get that information.
I have a question for this attorney.
Let me just make sure we have any other questions you'd like to ask. Okay. Can I just, do you have any recollection if while this request was pending, that there was still a criminal investigation pending?
I'm aware that that's the case, yes, but the question is if I have recollection of it. I'm aware of it in preparing for this hearing.
Okay.
I certainly wasn't aware of it at the time. I wasn't involved in this file, so.
Okay. Further? Do you have a question?
Yes. Why does it take a lawyer to redact dates of birth? That was all that was redacted in this case from a report that was available on November 16th and not produced until April 2014. Why does it take a lawyer to do that?
I'll object. It's argumentative. It assumes that the only reason for looking at the report is dates of birth.
If in fact the only material that was redacted were 2 dates of birth, do you think that's a good use of the taxpayers' money, sending this stuff around
I'll
from,
sustain that.
from
Now you're
bureaucrats?
going afield of for an FOI. I think that
Okay,
I'd like to rephrase
forget
it.
the taxpayers' money. If all that was redacted was 2 dates of birth from a document available on November 16th, 2013, not produced until after April 10th, 2014, what kind of deliberations would require that 4 months?
I think you're asking if you're questioning the way the department and the legal affairs unit is set up, the fact that we have lawyers working on these files. that's the way the department is set up, and that's the rules that we follow. I don't quite understand where you're going.
Well, I'm just saying, like, anybody who can read could have figured this out in like half a minute. And I don't understand the reason for 4 months of deliberations to hold back public information.
Objection.
Okay, sustained.
Okay. No more questions. Thanks for
I
testifying.
have a couple questions for Attorney Francisco.
Okay, go ahead.
You said that you weren't aware of any rhyme or reason that the report was not produced within, let's say, a month of when it was requested. Is that my understanding of it?
Objection. Mischaracterizes the testimony.
Sustained.
Can you give me your explanation? Can you state on record your explanation of why the document wasn't produced until 4 months later?
I don't have an explanation. I didn't work on it, so I can't. That's why I said before I would just be speculating.
Who worked on it?
I believe that there's been reference to an attorney that's no longer employed by the department.
So what happened to that attorney?
Objection, sir.
Yeah, it's relevant.
So when that attorney left state police for whatever reason, various reasons, I'm not going to speculate on the reasons, was that request handed to you?
No.
Who was it handed to?
When that attorney left, there was no request to be handed. You had already been sent the documents.
In other words, who was in the process of reviewing my request before I received the documents? Who reviewed my request before it was filled?
Again, I would be only speculating, but I believe the attorney that sent you the materials and who was working on the file would have been the one who reviewed the materials and sent them to you. I believe he signed a letter to you when he sent you those documents.
So you're saying you were not the individual that sent the documents? You were not the individual that processed this request?
That's correct.
So why was he not produced? When did his employment with state police end? And why are we left to speculate as to whether the rhyme and reason why state police didn't produce something promptly?
Objection.
Sustained.
Well, I came here for an answer. I didn't come here for speculation.
Objection.
Sustained.
So what you're saying is you guys stand before me today with no reason, no explanation for why my documents weren't produced 4 months later. I have no further questions if you guys are going to
We've had plenty of testimony.
Questions. I mean, I'm not an attorney.
No.
I shouldn't be expected to abide the same levels of a hearing in a court of law in a layman's kangaroo court.
Well, you can behave yourself. You can behave yourself as a layperson. You don't have attorneys aren't the only ones who have to behave themselves in public records, and you haven't done that.
Well, that's your opinion.
We didn't hide the public records. And
Mr. Tebow, would you like to wrap up for the case?
no.
No?
Well, yeah.
Like,
Yeah.
I'd like to make a closing argument.
so you do want?
Yeah.
You told me no.
Well, I'll say something to Attorney O'Neill later.
Then I would
But I want to wrap up the case. Is it my time to do that?
Yes.
maybe the best way to do that then is to submit written submissions. And
I'm going to say 3
and avoid the
sentences. I'd like
arguments.
not to be interrupted again. I'll be done in half a minute.
Okay, let's let him have his say.
Elements of the report written and produced on November 16, 2013 could and should have been produced promptly upon request on November 22. These public records could and should have been produced in a matter of seconds, if not minutes. Instead, they were produced 4 months later. That's wrong.
The position of the Respondents Commissioner is that Connecticut General Statute, Section 1-215, describes the obligations of law enforcement agencies to produce records relating to an arrest from the time of that arrest until the disposition of the criminal charges. And that statute gives to the law enforcement agencies the discretion to release what's been commonly referred to as the traditional police blotter information, name, address of the individual arrested, date, place, and time of arrest, and the charges. and then to add into that obligation at least one kind of a police record, either an incident report, police report, press release, or some other similar record. The testimony here is clear that the Department of Emergency Services and Public Protection chooses to comply with that statutory section by producing a press release. It then is incumbent on the public to seek records and information related to the arrest through ways that are traditional and much better known to Mr. Thibault and Mr. Avalucia than you and I. And that is to work the file, go to court, talk to the prosecutor, do the kinds of things that they need to do to follow up on the arrest. But we have, in every arrest case, every case where the Freedom of Information Commission is asked to consider the disclosure of a police report during the pendency of criminal charges, we have one important issue that is never addressed, and that is the interest of the accused. They're just that. They're accused individuals until the charges are disposed of, and they're entitled to the presumption of innocence. And if all of these police reports are disclosed right out of the box without an opportunity to be heard and allow the criminal process to be addressed, then we balance rights incompletely. So for those reasons, for the reasons articulated by our Connecticut Supreme Court, we submit that certainly we provided documents promptly. We gave documents that the statute didn't require us to give until a much later time. And we would ask that this appeal be dismissed.
Okay.
Am I allowed to say one further thing? Do we have time for me to say one further thing in closing?
Sure, of course.
I take objection with Councilor O'Neill's contention that it's our duty to essentially work our sources in hopes of getting some sort of a report produced to him. In fact, I would counter that I did work my sources. I went to the court and ascertained her file, and for whatever reason, her file with the accompanying police report, the police report was not in the file. So that necessitated the request. If state police or whoever was in charge of placing that police report in that file, then we wouldn't be sitting here today. Further, I would urge the commission to take into consideration that these representatives from state police, we don't have an attorney here present, and Mr. Francisco went on record saying that he couldn't vouch for a single solitary reason as to why these documents weren't produced promptly. He sat here and told you that. I would urge you guys to not lend yourselves to the impression that other people have had about the commission, that it is becoming a diluted, toothless tiger. And I would urge you to fine Lieutenant Vance or state police $1,000 for non-compliance with the prompt part of law. Thank you.
All right, thank you. I'll close this hearing at 10:45. I thank you for coming.